Sorry, Mr. Chair.
Thank you. Up next, Mr. Brock, you have the floor for 5 minutes, please.
Thank you, Chair, and thank you for the witnesses for your attendance today. I'll largely be addressing my questions to you, Ms. McClymont. And I think I want to continue on the thread from my colleague, Mr. Cooper, where he had left off in terms of the process by which Ms. Verschuren was ultimately appointed as chair. I know you can say hindsight's always 20/20, that reflecting on her finding of guilt under the Conflict of Interest Act ×2, you can say, well, I guess we should have taken some lessons from that and perhaps reinforced the conflict of interest provisions within the hiring sphere. But I guess what troubles me, and I'm sure troubles Canadians, is that there were red flags all over the concept of even entertaining the thought of hiring Annette Verschuren. Much communication happening from the past president and CEO, and nothing really was done. And I know, Ms. McClymont, you're relying upon the advice and basically saying we encouraged her to obtain information and advice from the ethics commissioner, and clearly she did. But the advice that she received from the ethics commissioner, she didn't follow. Not only she did not follow, but other directors did not follow. Hence, we're in this boondoggle of $390 million of taxpayer funds inappropriately being handed out to companies that were legally not eligible, and for directors basically patting their pockets. So this is leaving a real sour taste in the minds of Canadians as to what kind of shenanigans are going on with Justin Trudeau and his government. He told her point blank, not only do you have to declare a conflict, you must recuse yourself. She didn't do that. On the basis of that, she was found guilty ×2. So I want to go back to the process. You mentioned that there were under 10 applicants who were applying for this position. I want an actual number. And don't rely upon this is a privacy issue, because clearly it is not. I'm not asking for names. I'm asking for a finite number. How many people applied for the position of chair at SDTC?
Mr. Chair, as I've mentioned, there were close to 100 individuals who had applied for the chair position back in 2018.
You told me less than 10.
I was responding, Mr. Chair, I was responding to Mr. Cooper's question about the number on the advice letter that went forward. That was less than 10.
Well, let's go back. Over 100 applications?
Mr. Chair, I would clarify there were close to 100
Close to 100. Of that 100, you vetted that down to under 10. Is that correct?
That's correct, Mr. Chair.
Okay. What was the number under 10?
Mr. Chair, as I've mentioned, out of respect for privacy and
That's
personal
not good enough,
information-
Mr. Chair. I'll remind you, ma'am, of the supremacy of Parliament and the supremacy of this committee. The issue of privacy does not apply. I'm not asking for names. I'm asking for individuals that were mentioned in this referral letter that went off to the PMO and the minister's office. That is not a privacy issue. And if you claim privacy again, I will seek direction from the chair, because we have a right to demand that number and the documentation that flows from that. So I'll ask you again, out of respect, what is that actual number? I will not accept under 10.
Let me just interject here, just to assist the witness. So Mr. Brock is correct about privacy. Now, we're a long way from asking for any information from that. But I do think he is within his rights to ask for a number. Now, if you need to come back to us with that number, we'll accept that. At least that would be my recommendation. But I do think you need to provide a little more specificity, because there's a lot of numbers under 10. So if you would, please.
So, Mr. Chair, I appreciate your intervention. Our standard is that we don't divulge when it's less than 10, but I appreciate your offer to assess that and come back to the committee. So we will do that. We will check with our council and see if we're able to provide the number of names that were provided in the chair advice letter.
That answer is unsatisfactory to me. She's taking this request under advisement and obtaining legal information, legal counsel as to whether she can release that number. Again, I repeat that this is not a privacy issue that can trump the supremacy of Parliament and the supremacy of this committee. I will be asking this witness again to provide that information to this committee, an actual number of individuals that made it on the referral list.
Yeah, I will function here at the direction of the committee now. It is my view that if you have that number, you should provide it to this committee. There is no, from this committee's point of view, there is no legal obligation for us to wait for a response. Out of courtesy, if you don't have that, that'd be one thing, but that's not the answer you gave. It is also unusual for PCO to appear before a parliamentary committee like this. These are unusual circumstances because of this board. I would urge you to provide Mr. Brock with that answer. It does not violate any privacy considerations that you might be under that we are not under. And again, doing so, I think, would be forthcoming to this committee, which I think you should be. It would also steer us away from the committee taking additional steps to require you to provide that information. So I would urge you to provide the number to Mr. Brock, please.
I'm not, to be completely honest, I'm not sure if I have the exact number with me. So I would like to, if, Mr. Chair, if it is possible, if I could just verify and we could get back to the committee with the number, if that's okay.
Is that just for clarity? Is that something you can verify in the next hour, or are you seeking? Okay, that'd be helpful. Thank you. So we'll look for that, and we'll deal with this before noon, Mr. Brock. Mr. Brock, I'm afraid your time is now up. So you'll have another opportunity, I believe. Turning now to Ms. Khalid, you have the floor for 5 minutes, please.
Thank you. Thank you very much, Mr. Chair. And, you know, as I continue to participate in this committee, I always see people, witnesses who spend their time coming in, sharing in good faith information with this committee and being put through the ringer. It's unfortunate, and I obviously encourage continually to my colleagues to please respect witnesses and to respect the legislation under which we are governed. I understand and appreciate the relevance of Parliament in how we operate, but I also want to stress that there are branches of how we operate as a democracy, and that we should act responsibly with the powers and privileges that we are given within our Parliament. Now, Ms. McClymont, you had made reference to production of documents, and as you may know, there was a Conservative motion that had been adopted in the House requiring the production of documents related to SDTC to the law clerk with the intention of providing these documents to the RCMP. Now, the Conservatives are egging the RCMP to start criminal investigations, and I don't think that's fair. It is quite an abuse of the powers that they're privileged to have in our democracy. Now, if I'm not mistaken, as you indicated, PCO plays a central role when it comes to production orders of this type, leading the process and providing guidance to departments. With regards to this production order, multiple offices implicated have raised some serious alarm bells. Earlier this summer, the RCMP commissioner raised the alarm, saying that there were risks that this motion compromised its investigative processes and police independence. Now, in your experience, have you seen a production order from Parliament that compromises institutions' independence in this way?
Mr. Chair, I would just preface that, again, I am a senior official from PCO. To be sure, we are focused on the appointment side of the House. I would say for our part, consistent with my previous comments, we do take very seriously our obligations under the Privacy Act, and we do redact information that is of a personal nature to protect appointees so that they do feel they can come forward and put their candidacy and be protected. And so that is absolutely what we did in this context for our part in senior personnel.
What are the dangers of information? For example, if the candidates are their names are released or their general vicinity is released, what are the consequences to those people having seen the kind of dirt and mud that is slung at everybody in our democratic system in terms of applications, in terms of pushing forward the agenda of SDTC and of PCO?
Mr. Chair, I would say we really try to encourage people across the country to apply for these processes. I've over my time in this job, I've heard some very heartwarming stories of people who want to serve very, very much and are very grateful for the opportunity through an open process to do so. If that is breached, then we betray that confidence in people who have put themselves out there, who may not be successful for positions, who come from a very high stature across the country. So it would be very disappointing. It would cast a real chill for people to serve, and there's lots of public commentary these days about people not wanting to serve for a variety of reasons in a kind of heightened public and social media environment. So I would be very disappointed if we were to take steps that would anyway risk confidential information being provided that would hamper or cast a pall on people's interest in applying for positions.
But at the same time, we see that there has been an issue here. There's been a disconnect between the ethics commissioner, the AG, the PCO, with a candidate and their lawyers. How do you think that this transition to the NRC is going to help with increased oversight, for example, of these kind of appointments? What is your office doing to make sure that these kind of disconnects and that general mistrust in the entirety of candidacy that is not impacted?
Mr. Chair, I would say for our part, we will continue to look at ways to strengthen people's understanding of their obligations under the Act. I have spoken to the Ethics Commissioner myself if there's more things we could do in partnership together to make sure that people do understand their obligations, as one member pointed out, not from the beginning, but through the duration of their appointment. And I know the Commissioner does have tools in place to make sure that people are reminded of their obligations, and he offers training and other outreach. So I do think it's quite important, and it's something that we'll absolutely have to reflect on to make sure that people continue to understand their obligations under the legislative frameworks that they operate in.
Brief question, if you have one.
It's not brief, so
Then we'll
Thank
hold
you.
off. I appreciate that, Ms. Killian. So.